So are we now live? I think we are. Good afternoon to everybody. Thank you very much for coming, and nice to see so many people at this session. We are here to discuss the Financial Remedies Guide, which, as you will know, was published in March, just a couple of months ago, and now governs procedure for financial remedies cases in the financial remedies courts up and down the land. The background of this is, of course, as you will know, that the Financial Remedies Court began in 2021 formally, and in its early years has had a number of guidance documents and constitutional documents. And because of the way in which things have developed, that has produced a number of different documents and in different places. And it's been a little bit ad hoc in some ways. And so in December last year, Mr. Justice Peel, the head of the Financial Remedies Court, asked me to form a committee to update the guidance and also to tidy it up, to bring it in under one head. And I convened a committee, and it's the same committee. The committee is the same people who are on your panel tonight. So a special welcome to them. Nicholas Allen KC of 29 Bedford Road, and Lily Mottahedan of One Hare Court, and Rhys Taylor of the 36 Group, and Michael Allum of the International Family Law Group. They are all very distinguished, and many of them will be known to all of you, I am sure. We set out to draft a document to bring together all of the other documents, and by January we had produced a first draft. Then that went out to consultation to the usual suspects, the FLBA, resolution judges, etc. We had quite a number of responses, fairly detailed responses, some of them, and we then went through the guidance again with one eye on those responses. Eventually, we produced something that we were happy with. That went to Mr. Justice Peel, who approved it, and ultimately the President, Sir Andrew McFarlane, as it was then, approved the document and promulgated it formally in March 2026. So that's the history of it, and we regard this as an important step, another important step in the growth and the development of the Financial Remedies Court. Like other specialist courts, it now has its own guide. For those of you who practice in other areas, for example, Chancery, there's a Chancery guide which looks quite similar to it. And the plan will be to update this guide as and when is necessary, possibly and probably every year, because things do move fast. It's supposed to be a one-stop shop for all the guidance, which was in different places before. It replaces and supersedes the statement of efficient conduct at High Court level and also below High Court level. It also replaces and supersedes the primary principles documents and also various other more focused guidance documents, which are now replaced by what we have. It was intended not to be very radical, but to be more consolidationary, although there are some deliberate changes, we hope improvements in procedures, and some of those we'll pick up as we're going through this tonight. The fact that we've got this new guide has meant that there will be a need for some updated standard family orders, which themselves refer to the now superseded guides. And I'm pleased to tell you that the new president has approved an updated standard family order guide, or the selection of standard family orders, and those will be formally approved as almost his first act as the formal new president next week. So look out for that. Those will be promulgated next week, and they bring up to date the standard family orders, so they refer to this guide rather than the previous, now superseded guides. So that's the outline. What we plan to do tonight is have a fairly rapid trip through the different parts of the Financial Remedies Guide, and spend a few minutes on each of the important bits, and your panel tonight will take up the cudgels in relation to different parts of that. I don't know whether you have the Financial Remedies Guide on another screen in front of you, but if you do, one of the early new chapters, which is not featured so highly before in previous guidance, is the non-court dispute resolution part of the guide. And I'm going to ask, first of all, Nicholas Allen and then Rhys Taylor to talk about that. So, Nick.
Edward, thank you. Yes, I mean, this guide, as you say, Edward, is a mix of some old and some new. We have significantly expanded the NCDR part and brought it front and center in the FR guide. The paragraph that talks about the FRC judges being ever mindful of opportunities is fairly similar to the old version, but now we expressly reference the pre-action protocol, which is obviously annexed to Part 9 of the Family Procedure Rules 2010, and highlighting key elements of the pre-action protocol in the hope that that will give that protocol, pre-application protocol, even greater weight and potential to have some teeth if it's looked at during the currency of court proceedings in the future. So that's at paragraph 22, and we expressly highlight some of the key rules in the FPR, those that refer in part 1 to active case management, and where active case management requires consideration by a court of all forms of NCDR. And I think particularly important is highlighting towards the end of paragraph 23 that, of course, there's a duty on the court at all stages of proceedings to consider whether NCDR is appropriate. We cross-refer to the amendment to the cost rules that came in March a couple of years ago, that a reason to depart from the no order for cost starting point in financial remedy proceedings will be if there's been a failure without good reason to attend a MIAM and or attend NCDR. We have tidied up the wording as to what a financial remedies court judge may be entitled to ask after a private FDR if the private FDR hasn't led to resolution. The old wording, which I relied upon in a judgment, Mr. Justice Peel said was slightly wider than it ought to be. So we've taken the opportunity to bring our wording into line with Mr. Justice Peel's wording. And finally, for me, we have made express what is always thought to be implied, which is the obligation to make open proposals within 21 days of an FDR applies to a private FDR and not just a court FDR. The FPR itself just refers to court FDR, but we've decided to make explicit what everybody thinks, which the same rule in effect applies to private FDRs. Rhys.
Yeah, just before Rhys, may I just say, I meant to say it earlier, if you have any questions, please put them in the question and answer or chat bar, and we'll try and pick those up as we go through. So, Rhys.
Just picking up on Nick's final point, if I may, in respect of the open offers after a private FDR, that's to be found in paragraph 77. So there's a section on NCDR, but the open offers post a private FDR you find in paragraph 77. Just skating over a couple of things that Nick had to say, and then I want to say something about arbitration, if I may. The idea of NCDR and the system's determination to promote it is not going away. And so we had the Part 3 amendments a couple of years ago. We had the pre-action protocol in support of that. And the alert amongst you will have also noticed that there is a requirement in PD 27A to be alive to NCDR issues, filing FM5s as first appointment documents, and including in notes what the parties' positions are in respect of NCDR. I appreciate that not everybody is a huge fan of NCDR, and some people just like a good old-fashioned issue of proceedings and straight into the process. But there is a determination in the system and articulated in this lead document now about the importance of NCDR, which we would all do well to heed. Just in respect of arbitration, I think there's quite an interesting little innovation in paragraph 27, which I think people may have views about, but it is as follows: that if the arbitration starts life as proceedings and court proceedings are stayed to allow for the arbitration, there is a suggestion at paragraph 27 that there can be a direction of the court that in the first instance the parties will promptly inform the court that an award has been delivered. But secondly, providing the court has ordered it, and I think that's a really important feature of this, the arbitrator, having delivered their award, can contact the lead zonal financial remedies judge to inform them that an award has been delivered, so that the system is aware that there is an award which needs converting into an order. There have been a few anecdotes knocking around of awards having taken a long time to be converted into court orders, with a reluctance to go back to court to sort it out. And the idea behind paragraph 27 is to encourage a swift conversion of awards into orders. Nick, I know you were instrumental in sort of parts of this. Any feedback have you had about it? Pros or cons?
No, the only single sentence from me, if I may, just to add to what you've said about the innovation at paragraph 27, Rhys, about notifying the judge and getting effectively the equivalent of the post-private FDR directions hearing in the diary that we're all used to approve an order or deal with directions, is effectively, I think, one of the concerns that sometimes people have with arbitration is that if there are concerns that the litigation, even in arbitration, has perpetuated some form of domestic abuse, and the continuation of the proceedings is being used to continue that abuse post-separation, actually having a court hearing to deal with the arbitral award and convert it into an order should hopefully reduce that potential for that abuse continuing.
Yes, well, I'm going to endorse that. I've seen a couple of instances where it's taken quite a while for the matter to get back to court, and hopefully this suggestion will make that better in case in the future. We'll see how that goes. The next subject is allocation. I'm going to just say something briefly on that myself. It starts at paragraph 31 of the guide. Previous guides have not really talked about allocation within the below High Court judge level cases. This is a fairly new idea, and the distinction really is between complex cases and non-complex cases. Most cases will not be complex, but some will be. So if you are a solicitor, for example, filling in the allocations questionnaire on the portal when you're launching a financial remedies application, don't forget to tell us what you'd like it to be in terms of whether it's complex or not, why it's complex, how much money is being argued about. If it is complex and the gatekeeping judge in each zone, in London that will be me, in other parts of the country it will be the lead judge or somebody authorised by the lead judge, will then decide whether it's a complex case or not. If it is a complex case, Different zones have different ways of dealing with it, but certainly in London, I will allocate a particular complex cases judge, and there are a number of judges who are on the complex cases list, some fee paid, some salaried, and they will take that case through, in theory anyway, right to the end and send it somewhere else for an FDR, whether that's a private FDR or another complex case judge FDR. So you'll get judicial continuity, and hopefully you'll get a judge who will give you a good service. That's the idea anyway. So don't forget to make those applications. As well as that, an important area is the allocation between High Court judge level cases and below High Court judge level cases. This is one area where it has changed slightly. The figure, which has been for about 10 years, £15 million has been the sort of guideline figure. That's been increased more or less by inflation to 20 million. So if your case is worth less than 20 million overall, you're pretty unlikely to get it transferred up unless there's some very, very powerful reason for that. If it's above 20 million, you've got a good starting point for getting that allocated up. As well as that change, there is the now consolidated change as to how that is done. The old way of just sending things to the Royal Courts of Justice in London, that's been discontinued, so please don't do that. Make the application on the portal, put it in as much information as you can in the gatekeeping part of your Form A as to why this case needs to go to a High Court judge, if that's what you wish it to do. That might get picked up by the gatekeeping judge. If it doesn't and you're still unhappy with that, then please make an application. And the application, there's a procedure now within the new guide for the lead judge to see that application and then to communicate with Mr. Justice Peel as to whether the matter goes up to the High Court. It's quite a smooth process. It happens on a weekly basis. But please do that. Please don't try and bypass the system by going straight to the Royal Courts of Justice anymore. That's been discontinued. And please don't make an application just before the first appointment. What sometimes happens is that it goes through the allocations procedure. First appointment is listed, and then 2 days before that, an application comes in, and it may be right for going up to the High Court judge level. But that might mean the first appointment has to be vacated, which is a waste of everyone's time. So please don't do that. Please, if you want to do this, make the application either at the earliest point, or if you're going to make it to the judge at the first appointment, and a judge at a first appointment will know what the procedure is and to contact me, and I will then contact Mr. Justice Peel, and then we'll decide whether it goes up or not. So please do read those paragraphs that are dedicated to all of that. It is significantly different from what it used to be a few years ago. So don't forget to have a look at that if you've got cases in that category. So also in the subject of allocation, there are some bits in the guide as to particular types of cases, and Lily and Michael are going to talk about these. So I'm going to ask Lily first, and then Michael to talk about some of the specific types of cases. Lily.
So in the guide, there are 3 categories of applications that are now expressly referred to. One is freezing order applications, one is humane injunction applications, and the other is applications for leave under Part 3. In terms of freezing injunctions, nothing has changed between this guide and previous guidance, and it's still the principles in UL and BK that apply, and in terms of allocation, it's as before. If it's a case that meets the High Court criteria, it ought to be in the High Court, subject to the allocation procedure that Edward has just referred to, and if the case is below High Court level, then the application should be made at the below High Court level. What's new in the guide is the express reference to humane injunction applications, which in my view sort of signals, again, part of the development of the Financial Remedies Court, not only as a specialist court with regards to financial remedy, but also in particular cross-border cases. And what this signals is that jurisdiction and forum disputes in the context of a divorce suit are now firmly under the umbrella of the Financial Remedies Court for obvious reasons, because the outcome of that, of course, will affect whether or not the relevant financial remedy application is going to be proceeding. And so the guidance on humane injunction applications is, again, as with freezing injunction applications, they can be made at High Court level or below High Court level, subject to the complexity criteria and allocation decisions, which again, Edward has just referred to. Before this guidance, there was a little bit of confusion, we understand, both in the profession and also in some corners of the judiciary, that humane injunction applications could only be made to a High Court judge. And in fact, Mr. Justice Peel told us that there was, which I couldn't locate it, so maybe it's gone, but there was a reference to in one of the MOJ websites that humane injunction applications could only be made to a High Court judge. That's not the case. And so just, again, have in mind the complexity criteria. I'm going to hand over to Michael to talk to you a little bit about applications for leave under Part 3 and what the guidance says about that, probably referring to a case that I appeared in at the end of last year. But since he produced a beautiful summary of that for Class Legal and various other publications, I'm going to hand over to him.
Lily,
Michael.
thank you. I suspect most people on this call are aware of the Supreme Court decision in the case of Potanin in 2024 in relation to claims that can be made for financial provision under Part 3 of the 1984 Act after an overseas divorce. We're probably all aware that prior to that decision, the procedure was to make the application for leave and also for that application to be determined, usually on a without notice basis. One of the things that the Supreme Court told us in 2024 was that that process is unfair and that going forwards, they felt the majority of cases, leave applications should be made and considered on notice. That's been picked up in a couple of High Court decisions since. Most notably, there's the decision of Mr. Justice Moore in TY and XA, that's a 2024 decision. And there's also the case that Lily referred to a moment ago, case of AT and NT. It's a decision of Mr. Justice Peel from towards the end of last year. Some helpful passages in that judgment. Mr. Justice Peel says that in his role as the lead judge of the FRC, he's been encouraging judges and he's been encouraging court officers to list Part 3 leave applications on notice. He says that he struggles to envisage many cases post-Potanin where there would be a compelling justification for a leave application to be heard without notice. And he concludes by saying that leave applications should now be listed on notice unless there is some exceptional reason for applying without notice. All of that guidance has really been imported into the Financial Remedies Guide. If you look at paragraph 50, you will see that it now says that all applications for Part 3 leave will ordinarily be listed on notice. I think the only one remaining wrinkle relates to the family procedure rules. They were obviously drafted at a time when the practice was to make these applications without notice and for them to be determined without notice unless the court directed otherwise. That at the moment is still what FPR Rule 8.26 says. But Rhys, I wonder whether you may be able to shed some insight for us in terms of if that might change and what the time frame for that may be.
Yeah, so the long and short of it is it won't be changing anytime soon. I'm on the Family Procedure Rule Committee, and I can tell you it has a very, very full agenda. And sort of people say, oh, why doesn't the Family Procedure Rule Committee sort this or sort that? It's because it has an overwhelming amount of work. There's a published tiered agenda. I think there's currently 46 items that require attention. There's a tier 1 agenda items, which are those which are on fire. A tier 2 is the ones they'll get to once the flames have been doused in tier 1. And then there's tier 3, which is a quieter corner of the agenda. We'll get to those when we can. And I'm afraid to say that the suggestion that we amend the rules to be in accordance with Potanin is languishing in tier 3. And so we're now in a sort of slightly curious position where we would be actively saying, follow the guide rather than the rules. Now, in law school, they would say, follow the statutes and then follow the statutory instrument and then, follow guidance afterwards. But in this particular instance, family law is a bit of an island, isn't it? You do need to follow the guide rather than the rule.
It's a good illustration of why we need a guide, really, because the rules tend to lag behind. But this particular rule, I don't think is doing any particular harm. It needs to be changed at some point. But the guide and the judicial guidance, we've been able to get around that problem. Anyway, we're going to move on to another topic. Just before I do that, somebody has contacted me to say that the chat box has been disabled. So I don't know whether somebody's able to, if that is the case, whether that could be reactivated. So we might get some questions. Anyway, we're going to move on now to the next topic.
If I could just chip in very briefly, there is also a Q&A box, and so the chat box may be disabled, but there's a Q&A box where people can post questions.
Okay, that may be the reason the chat box is disabled. So try the Q&A box. Right, we're going to turn to first appointments, and this is an important part of the guide. Nick.
Edward, thank you. Obviously, the first and most important thing to observe is it is correctly called a first appointment and not a first directions appointment. And that's obviously the only reason why I wanted to be on this committee, to ensure that that phraseology, was shepherded correctly into the final version of the guide. We have, as part of the consolidation of the two efficiency statements, divided, as we've done in other parts of the guide, first appointment guidance, both below High Court level at CJ and DJ level, then a separate section, High Court level, and then where there are parts that are common to both. Dealing with the below High Court level, first of all, we've made express the usual time estimate for a first appointment. I think, Edward, you'll correct me if I'm wrong, but I think the London zone defaults to 60 minutes, or certainly the CFC defaults to 60 minutes. It's within each zonal lead sets the default time for their first appointments in their zone. And so some are 45 minutes, some are 60. And it comes back to the point Edward was making before about complex cases. And if a case is allocated as a complex case and given a complex judge, that's not a reference to their personality, but a reference hopefully to their ability to deal with the case, there may be a slightly longer time estimate. We have dealt with the fact that there is the obligation 14 days before the first appointment to file a market appraisal in respect of the value of the family home, or competing marketing appraisals, brief indicative evidence as to mortgage raising capacity, and some property particulars, in the hope that for perhaps the more straightforward cases and subject to there being sufficient time on the judge's list, the first appointment can be treated as an FDR appointment if borrowing capacity information, housing particulars, and valuations of the family home are known. I think the equivalent wording to those obligations, which appears on the Form C, is now slightly out of date. I think our wording is obviously a bit more up to date. So if and to the extent there is a conflict in the wording that appears on the Form C when that is sent out by the court, which is obviously the notice of the first appointment, and the wording that we've put in paragraph 52 of the efficiency, the FR guide, please use the more recent wording. Looking at High Court level, there's now an express provision for the first time that High Court first appointments will either be listed with a time estimate of half a day or 1 day. No doubt if you're applying for the case to be listed before a High Court judge or a deputy for a first appointment, no doubt you'll indicate when you seek that allocation or reallocation what you think is the appropriate time estimate. We've tried to give further weight to the accelerated procedure that I know, Michael, I think you're going to talk about in just a moment. We've tried to remind parties of the benefits of using the accelerated procedure to get agreed directions and therefore hopefully to be able to vacate the first appointment. We have reiterated the need to limit a questionnaire in most default cases to 4 pages, the obligation to file the FM5. Just highlighting paragraph 57A, which is where we now have the obligation to file the ES1 and the ES2, and picking up Rhys's point about guidance not theoretically being able to overrule statute or statutory instrument. There remains buried in FPR 9.14 subrule 5 the obligation to do a chronology in advance of a first appointment, but we took the view that that can most usefully done by filling in the boxes in the ES1, and if that's done, there is no need to also do a chronology. The only other point that I wanted to highlight is in relation to if you're attending a court first appointment and you are inviting the court to allow the parties to attend a private FDR appointment rather than a court FDR appointment. Particularly, this is paragraph 60. We have amended and expanded the wording that relates to the identity of the private FDR evaluator. I know it's certainly, Edward, your preference that the identity of the PFDR evaluator and the date of the FDR has been agreed in advance of the parties attending before the first appointment. There is a tension between how the entirely voluntary nature of a PFDR and the court's ability to perhaps identify the evaluator if there is a dispute. I think that's a slightly unresolved tension, and there may well be something that may well develop in jurisprudence in the months or years ahead. But for the moment, what we have alighted upon, and this is the last 4 lines of paragraph 60, and this is new, that if the identity of the evaluator and the timing of the private FDR appointment cannot be agreed between the parties, then the court is likely to seek to assist the parties in reaching an agreement on these issues, or at least in reaching agreement on a mechanism to determine how they are to agree. So the focus has been on the court assisting the parties to come up with a mechanism to reach agreement, but that, I think, is probably a reflection of the slight tension of the court wanting to assist, wanting to move matters on, but knowing that the process is, for a private FDR, entirely voluntary.
Yes. A judge will be very reluctant to say that one private FDR evaluator is better than another one, but will want to make sure that there is going to be a private FDR if you're opting out of the court system. So thank you for that, Nick.
Could I just chip in with a short point as well? I've had a few cases where an event for NCDR has been ordered by the court, and I can think of one case in particular where it was directed will take place at a particular chambers, and then somebody who wasn't overly enthused about this said, well, I'm only attending remotely. And, it was quite clear in the order that it said a particular chambers, but I wonder whether if, one gets a sniff of that kind of problem, one should also include in the order and shall attend in person.
Okay, we'll leave that thought hanging, and I'm going to go to Michael to talk about the accelerated first appointment procedure.
I suppose, first of all, for anyone who's not aware what the accelerated first appointment procedure is, it's the process that we as practitioners should be following in the event we want to try and agree directions in lieu of a first appointment. Three changes I think really that we need to be aware of. The first is paragraph 54 of the Financial Remedies Guide now actively encourages parties at all levels of cases, whether it's High Court level or below High Court level, there is now active encouragement to try and agree directions in advance and use the procedure. That's a change from the previous wording. The accelerated first appointment procedure previously anticipated it would be relatively few cases that would go through that process. There is now active encouragement instead that we should be trying to do this. Change number two is there's a amendment to the accelerated first appointment procedure itself. It's been attached to the guide. You can find it at Annex 2. Some of the main changes, there is now reference to the fact that the application will need to be made on the court portal in the usual way on a form D11 with an agreed order signed by or on behalf of all the parties. There's reference to the documents that the court will require in order to approve such an application. It's obviously the bodies of the Forms E, it's the ES1 and ES2 as well. Crucially, the FM5 should be filed, giving the parties' views on NCDR. And then probably most importantly, or where sometimes it runs into trouble, questionnaires. Questionnaires need to be agreed and they need to be filed on the court portal so that the judge deciding whether to approve the directions can also have a look at the questionnaire, check that they're relevant and proportionate. I think what you're certainly not going to get away with anymore is including a direction in the order that says questionnaires save for just exceptions. I think in those circumstances, you'll probably find that the order is not approved and you'll have to attend the first appointment. Final change or significant change in the procedure is the time frame. Previously, it was requested that these applications were made 14 days before the first appointment. That's been reduced to 7 days. It's really trying to balance practitioners and parties have an enormous amount of work to do between the date the Form E is due and the first appointment. It's trying to factor in that, also being mindful of the pressure on the court resources and that courts do need time to process and approve these applications. So the compromise we've gone for is 7 days to give the court hopefully enough time to try and look at it beforehand. A final change to be aware of is there is an amended draft order as well. That's also attached to the guide. You'll find that at Annex 3. Obviously, it can be tailored depending on the particular case and the directions, but it's a very good starting point in terms of the sort of precedent order the court will expect to receive, including reference to the documents that the court would need uploaded to the portal to consider such an application.
Thank you very much, Michael. And there's a question which I'm going to deal with in a minute. But first of all, I'm going to turn to the next section, which is about final hearings. Again, Lily and Michael are going to share this. So, Lily, I think you're going first.
Yes. So in terms of final hearings, some of the sort of key elements of homework to be thinking about is in the guide. One of them concerns listing and the need for a PTR. The guide hasn't changed too much in that regard, and effectively, for a final hearing in the High Court, there is an automatic PTR that needs to be listed when listing the final hearing. And then for cases below High Court level, it's only automatic that it needs to be listed if the case is listed for 3 days or more. Obviously, that doesn't stop parties in the right case attempting to list a PTR or attempting not to have a PTR. And certainly in a recent case of mine, even though the time estimate was a lot more than 3 days for various reasons, both sides and the judge agree that a PTR wouldn't be necessary. The other thing to bear in mind when listing final hearings and proposing a time estimate is to make sure that you leave enough time for judicial reading and judgment writing. It's quite tempting as practitioners to focus only on the time that we need in court to put our case. We also need to make sure that the judge has time. The other thing that I think is quite important is in relation to witness statements. The guide is very clear that the primary witness statement evidence, best practice is that it be 15 pages, so 15 sides. And I think that using the guide, therefore, will hopefully limit the disputes and the debates as to page numbers and how many pages someone should be allowed and how many pages in response, etc., where the starting point under the guide is effectively 15 pages. That doesn't change the fact that the relevant practice direction in the family procedure rules give a maximum of 25 pages. This is not one of those things where we're saying the guide prevails and you can completely ignore the maximum 25 pages. What we're saying is that the best practice is 15 pages, but if you have a good reason to ask for more pages at the time when the case is being timetabled, then the maximum is 25 pages. The other thing to bear in mind is trial templates. Normally, that's something that your counsel would agree between themselves, with solicitor approval, as it were. And the guide is clear that that's something that we need to agree effectively on or before the PTR, because obviously the PTR is very much about making sure everybody's done their homework and seeing that we're on track for a effective final hearing. Michael, I think, is now going to tell you a couple of things, particularly from the solicitor perspective, about the contents, I think, of witness statements, because obviously most of the time it's solicitors who are taking the lead on drafting and some of the practice direction documents.
Thank you, Lily. On contents of witness statements, I think it's really a reminder of the President's memorandum on witness statements of 10 November 2021. I always find it's a really helpful document just to remind yourself of before drafting a substantive document, a substantive witness statement. But probably the key takeaway for me, particularly on the solicitor side, is, of course, it can only contain evidence. What the statement should not be doing is seeking to argue the case. I know on the basis that it's probably more often solicitors that are helping clients draft witness statements rather than counsel. I know we probably all have that tendency to want to jump in and include some of the law. It's trying to remember that the job in the witness statement is just to put forward the evidence in the witness's own words. It's the position statement later on that would argue the law. So I think mainly it's a reminder of the President's guidance on that. That's the main takeaway for me. In terms of hearing documents, we have the ES1 and the ES2 that are of course required for all other hearings, but for the final hearing, you will need a composite chronology and you'll also need an agreed statement of issues. In terms of allocation of work, I often find it might be the solicitor side of the profession that may start and do most of the chronology. It might be counsel that may do more of the statement of issues to be determined. Both are due on 11 a.m. the day before the final hearing. I think the key takeaway in terms of the chronology is to try and keep it as neutral as possible. I'm sure we've all seen those cases where each side gradually try to add something else in, becomes a very long document that lots of hours are spent on and ultimately never is agreed. I think what judges find far more helpful is a fairly concise chronology that's in neutral terms, just identifying the key dates that are actually relevant to the proceedings rather than trying to run a case through a chronology.
So would one of you like to deal with the question in the chat bar? What happens if one side breaks the rules and puts in a witness statement that's longer than it should be? What should happen?
Well, I think it's legitimate to bring that to the judge's attention and to say that there's been a breach and there's been forensic cheating and that it's unfair. And quite what the judge does with that is, of course, a matter for the judge, but applying the overriding objective and the need to be fair to both parties. If one side is under the limit, I can see the argument for, if the facts are right, for saying, well, some of it's going to have to be redacted.
I've had this problem recently, I should say, in a case, and my advice, and obviously subject to the eminent judges and part-time judges on the call, is that if you're for the party that is exceeding the page limit, not to simply serve it on the other side as a fait accompli and hope they won't make any noise about it, but to acknowledge it from the get-go and accompany the service of that witness statement with an application for permission to exceed the page limit. I say this, and that doesn't mean the judge is going to be with you on that, but I think that at a minimum is, as it were, the respect that needs to be shown to the rules and to the opponents. I would say, though, from my recent experience, is that it's one thing if it's over a page limit, for instance, the 15 pages that we say is best practice guidance, or a lesser page limit. But I think if the witness statement is in excess of the 25 pages permitted even by the family procedure rules, it's very unlikely that you will get that permission. And in that situation, which is a situation that I found myself in recently, it's more likely than not that the judge will effectively say, look, you need to refile it within either the original page limit or a page limit that's not in excess of what the family procedure rules provide. But again, I defer to Edward on that because
Well,
he's at the
I'm going to
coalface.
answer. I'm going to answer a different way. I think it's very difficult to know what to do, but I'm going to answer a different question, if I may. Someone asked, can we have a link to the recording? I think it will be on FRJ website when we're complete, so that will be easy access to that. I'm asked the question of whether litigants in pers can use the accelerated procedure scheme. The answer is that they can. They can't do it on the portal, but they can do it by sending an email to the court in the normal way, and hopefully that will be picked up and dealt with. It's not always possible, but it sometimes happens. I don't think litigants in person are very good at accelerated procedure, but there may be examples where that happens. I'm also asked, good question, how on earth do we get the court to deal with an urgent divorce jurisdiction dispute? And there's particular reference to the CFC, so I feel that might be targeted at me. This is another difficult question, because obviously if it's just an application relating to a divorce, then that divorce is likely to be on the portal, and the application has to, first of all, in the first instance, to go to the divorce portal. What's supposed to happen is that when they get such an application, they refer it to us. It's supposed to get listed, and if it's urgent, hopefully that will happen quickly. It sounds as though in this example that didn't happen. I'm sorry. I'm sorry, Tessa Bray, that didn't happen in your case. So that's the technical answer. In practice, if it is really important, then please do email the Financial Remedies Court and explain what the situation is, and if it relates to money, then we can be interested, and hopefully somebody will refer it to a judge quickly. We have all the problems with shortage of staff, but we try and deal with urgent things urgently. I know we don't always succeed, but we do our very best to do that. So there are ways of tackling that sort of an issue. Anyway, we're going to move on to the next topic, which is bundles. Rhys, a favourite topic of yours. What do you accept of bundles?
Yeah, so I'm just looking at one of the questions as well, which is I think ties in with this, because the question is about timescales or position statements compromised if bundles are late, and that's what the Family Procedure Rule Committee had in mind in amending Part 27A in respect of bringing forward, in respect of bringing forward the time for filing a bundle. So previously, I think it was 2 days before, and now the timetable in PD 27A reiterated in the guide is for parties to be discussing the bundle 7 days in advance, bundle to be available to be filed and served 5 days in advance. And if that's done, then even if there's a little bit of slippage, there's a fighting chance that all of the relevant documentation is going to be before council in time to be able to do what they need to do. So that is the reason why the timing has been brought forward to help everything run a bit more smoothly. A particular bugbear, excuse me, a particular bugbear is the difference between internal page numbering and PDF numbering. Now, this might not seem like that much of a big deal. Oh, it's only 2 pages, and it's quite easy to chase it up. But actually, whether as an advocate or as a tribunal, there is a lot to think about. And if you're constantly subtracting for page numbers. It's just another thing that everyone has to think about. And it doesn't seem to me that there's any good reason why the page numbering and the PDF numbering can't match. I mean, the usual problem is that the index is either numbered or not numbered, and then the bundle follows with it either matching or not matching, depending on whether or not the index was numbered as well. And some bundle programs put sort of little mini contents pages at the start of each section, which also sometimes throws the page numbering out. And it doesn't seem to me that needs to happen. Just have the PDF numbering and the internal numbering matching. So you'll find all of this either in PD27A or in paragraphs 81 to 87 of the Financial Remedies Guide. There's also reference to the possibility, or rather than having a paper bundle, using an electronic bundle in the witness box, but that would have to be on the basis that the parties have made arrangements for an acceptable electronic device to be in the witness box. And I rather suspect it will be in extremitis that the judge is happy to agree somebody to use their own laptop. I think it would have to be a neutral device, which has just been put in the witness box for the purpose of allowing the bundle to be accessed. So there we are. That's bundles. They do cause a tremendous amount of difficulty if they're not done right. Something which isn't in PD27A or in the guide, but I think is a good practice point, is to have the exhibits to statements bookmarked. Quite often you can have a statement with dozens of exhibits, and either poor old counsel or poor old judge are going through trying to find the relevant exhibits, and if they've just been bookmarked in advance, that would greatly assist things.
What does the PD say about bookmarks, Rhys?
So it says that all documents should be bookmarked. And so at the sort of rougher end of bundle preparation, sometimes you don't have all of the documents bookmarked. So each individual document has to be bookmarked. But, someone could legitimately say, I bookmarked that statement, I've complied with the rules. But you've got to think about the navigability of the information within that document. And if it's got 15 or 20 exhibits, it becomes so much easier to find your way around all of that if all of that is sub-bookmarked.
So I totally agree. From a judge's point of view, getting a bundle with no bookmarks is a very depressing experience. It's not properly. There's a question in the chat. This won't be one for you, Rhys. What about WhatsApp messages in bundles? Does the PD say anything about that? Yeah. So the starting point is that there shouldn't be photographs and what I'm going to call electronic chatter put in a bundle. Now, it may well be that the case turns on electronic chatter. And so if it's relevant, then it can be produced in an orderly way. But what the PD27A and the guide is trying to stop is just the sort of indiscriminate bunging in of loads of WhatsApps, some of which are rotated 90 degrees, some are upside down, some are chronologically out of order, some are slightly, cut off and that kind of thing. And it's a jungle of chaos and impossible to absorb that information. And so it's not just chuck the WhatsApps in, it's await a case management decision by the court as to how they can be produced in an orderly way. I mean, clearly, if it's something urgent that you will be referring to, the PD27A doesn't stop you
putting in documents that will be referred to, but it's
So,
just trying to stop the chaos.
Peter Hatvarney asks, what about using the court pool laptop for a witness bundle, or perhaps a laptop provided by one of the parties? Does our guide encourage that, or does the PD 27A encourage that?
Off the top of my head, I can't remember precisely. It says, I think it just says an electronic device. And so if an appropriate electron, see if I can find it. If an appropriate electronic device.
81H, I think it is 81H in our guide. It refers to it.
Yeah.
So
okay.
if we could move to having no paper bundles, that would be a good thing.
Yes.
So, yes.
But I think some care needs to be taken. You don't want people going into the witness box with their own device, with their own sort of annotations and sort of side notes that they want to look at. I think some care needs to be taken that it is a device that will be neutral for the purposes of the hearing. I have seen judges say, after the witness has confirmed on oath, will you confirm that you are only looking at the PDF on that device?
Yes, absolutely. Another topic, position statements. Nick, you're going to talk about this.
Yes, and this is obviously the most important part of the webinar. This is why all 415 people have joined, and that's not to talk about the length of position statements where there's been no change from the previous two efficiency statements, slightly longer position statements allowed at High Court level than below High Court level, and the various page lengths are set out at paragraph 89. The most important point, though, is the lengthy debate we had, which is at paragraph 89D of the guide, which is the font in which position statements must be in. There was a lengthy discussion over what font this guide would be in, and there was a heated debate as to whether it should be in Arial or Times New Roman, and I don't think I'm breaching any confidences to say that that PLJ had to determine that particular dispute because the committee were not all agreed. The first version of this guide said that position statements were to be in either Times New Roman font or Arial font. I am, of course, bound by collective responsibility, but I am the author of the addition of the word ordinarily, which is doing a lot of heavy lifting in that sub-paragraph, as is the reference at little c to not less than 12-point font. I have regrettably made it clear to the National Lead Judge and the Deputy National Lead Judge of the Financial Remedies Court that I will continue to be doing my position statements in Calibri 11-point font. If anybody wishes to act pro bono on my application,
someone mute him.
For committal, I will be very grateful. That is all I wish to say on position statements.
Okay, a little bit of revolution there, but I hope nobody will be following him. So another topic is orders, and this I want to draw your attention to some new wording, which is not in any previous orders, which is paragraphs 94 and 95 of the FR guide. And what it says is that orders should be agreed and drafted and lodged within, on the day if possible, but if not that, within 2 working days of the hearing. And if that is not possible, then within 24 hours of that deadline expiring, the parties should send to or the advocate should send to the judge an explanation as to why they haven't been able to do that and what the differences are. That's, I think, is new wording. A lot of judges get very frustrated about how long it takes to produce an order. It may be that there are good reasons in quite a lot of cases, and what I find is that one advocate always blames the other advocate for delaying it. And if both advocates just got on with it, it might happen. And if you're worried that the judge might shout at you, that's paragraph 95 that you need to bear in mind. But it is important not to let that slip. because the sooner order is made, the sooner everybody knows where they stand. And the last topic before we close this webinar somebody's already said on the chat, I don't see this is going to be complied with. Well, we'll see what we can do on that. The last topic in this webinar, because we have to wrap up at 6 o'clock, and we're nearly there, is well-being. Nick, you want to say something about that?
Just a sentence, Edward, thank you. There's no actual change to the wording that's at paragraph 97 of the guide, which replicates what was in the former efficiency statements. But many of you will know about the recently published supplemental report of the Family Solutions group, which was expertly chaired and the lead authors of Edward Cook Family Law and Charlotte Bradley of Kingsley Napoli. And the FSG report says a lot about well-being and professional supervision. And I think, Edward, that's probably one of those areas that we'll look at and see about developing in future editions of the guide in the years ahead.
So thank you. So I've just noticed on the chat, somebody says, if you've got a direct access, public access council, how do they get their position statements to the judge? The answer is put them on the portal. Please put them on the portal. Direct access council do have access to the portal. All they've got to do is ask for that access. So that shouldn't be a problem. Right. I think that brings us to 6 o'clock. I think I saw 462, I think was the highest number of participants. It says a lot of people. Thank you very much for attending. We're now going to bring this to an end. As I've said already, it will be available on the FRJ website should you like to see it again. Thank you very much and good night to everybody.